The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have 3 cases that will be submitted. Those cases are State of Iowa versus Jane Doe. Second case is in re the detention of Thomas Ruthers, Jr. The final case is Isaac Ortez versus Lloyd Rolling Construction and Grinnell Mutual. That last case is now submitted to the court without an oral argument, and will proceed to hear the arguments in State versus Doe. Mr. Poggenklass.
Thank you, Mr. Chief Justice. May it please the court. My name is Rob Poggenklass. I represent the appellant in this case, Jane Doe. This case is about the state's different treatment of 2 types of individuals: indigent criminal defendants who owe court-appointed attorney fees to the state, and criminal defendants who are able to retain private defense attorneys for their defense. Under Iowa Code 901C2, the dismissal, acquittal, expungement law, the state denies expungement to the first group while allowing it for the latter. This disparate treatment of indigent defendants who owe court-appointed attorney fees violates equal protection, both under the Iowa and federal constitutions. Equal protection demands that all persons similarly situated should be treated alike. If a law draws classifications based on certain characteristics, such as race or gender, courts review it with heightened scrutiny. When the law addresses economic concerns, as in this case, courts review whether the state had a rational basis for enacting it. But even when a court does not single out a class for heightened scrutiny, that does not leave the group unprotected from invidious discrimination. The rational basis test is deferential to legislative judgment, but it does not lack teeth. In James versus Strange, the United States Supreme Court said that a state may not impose unduly harsh or discriminatory terms on an indigent defendant merely because the individual owes a debt to the public treasury rather than to a private creditor.
What about the finding that's required for a district court to conclude that there was a reasonable ability to pay?
Sure, Judge. Mr. Justice, I'm sorry. That finding did not happen in this case. This case was dismissed a few months after this court decided State v. Dudley, which mandated that finding. That's not on the record in this case, but I think even if there were a finding of a reasonable ability to pay, that doesn't fix the circumvention of debtors' exemptions that happen when the state denies expungement under this law.
Well, what should we do with the lack of that finding in this case? Is that a reason for specific? Would it make sense to require expungement when the finding of a reasonable ability to pay was not made?
I'm sorry, can you restate, Mr. Justice?
Well, I'm just want to brainstorm about some potential outcomes or remedies here. Sure. And since the record in this case is silent, or there's no affirmative showing in the record that Doe had a reasonable ability to pay these attorney's fees, would it make sense to say the state should concede expungement or not resist a motion to expunge when that finding does not exist in the particular individual defendant's record?
The problem that I have with denial of expungement, even if there is a reasonable ability to pay finding made in a case, is that the state is still denying expungement to people without a look at the normal exemptions that are afforded to civil judgment debtors, which is specifically what James versus Strange does not allow.
Is there a difference? You know, Strange involved, you know, the exemptions available to other debtors were not available for court debt, so they could affirmatively go and garnish wages on a low-income person for court debt, but not other debt. Is there a difference between withholding expungement and affirmatively pulling money out of their paycheck?
I think so, because expungement is, in a lot of cases, is what allows a person to get back to work. You know, criminal records are very important to employers when considering whether to hire someone. So I think the affirmative step that the state is taking in saying, this person can have expungement because they hired private counsel, and this person can't have expungement because they owe their fees to the state, is very similar to what happened in Strange.
But didn't the Strange court acknowledge the state's interest in collecting court debt, and that it's okay in some instances to provide incentives for the collection of court debt?
Absolutely. The court in Strange acknowledged that, the court in Fuller versus Oregon acknowledged that, and this court in State v. Haynes acknowledged that the state has a legitimate interest in recouping the costs of indigent defense fees. But the 14th Amendment and Article 1, Section 6 of the Iowa Constitution say that the state cannot treat indigent defendants who owe those fees differently than it can treat an individual who owes their private attorney.
You keep saying indigent, but really, to put a finer point on it, the distinction is between indigent defendants which should have happened in this case, who are determined to have a reasonable ability to pay, and those who retain private counsel, right? Isn't that really the relevant distinction in most of the cases? I realize the finding did not occur in your case, but that's the distinction the law is making, correct?
Well, the distinction I'm trying to make is between people who owe their fees to the state and people who retain private counsel and therefore owe their fees to a private creditor.
And then again, I mean, you say owe their fees to private counsel. I mean, we all kind of, you know, in the real world, with criminal defense retained counsel, usually in order to enter appearance, they require a retainer. Generally, if not always, probably not always, but often, that retainer ends up being the fee for the representation. So usually those people don't owe, at the point of expungement, don't owe money to their counsel, right?
I would have no way of knowing that, Mr. Justice. Sorry.
Well, let me follow up on this, on the issue of willfulness, let's just say. You talk in your brief about heavy burdens and so forth, and Strange uses that language. Is there a distinction, though, between someone who has a court cost but has ample ability to pay? And you seem to be suggesting, I think, well, even a wealthy defendant who's got a couple $100 of court costs, just kind of refuses to pay, that person is entitled to the protection you seek. Does that make sense?
A wealthy person who owes court-appointed attorney fees?
Yeah, who just willfully doesn't pay, basically, and maybe has hid the assets. And
well, the state has remedies in that situation. The state has Chapter 626 and Chapter 642 to do execution or garnishment. So if we're talking about someone who has the resources, the state can use those collection tools which provide all the debtors' exemptions allowed under Iowa and federal law and to get that money and get the court-appointed attorney fees back.
If we assume that the findings made that there's a reasonable ability to pay, and we acknowledge the state's interest in encouraging recoupment of court debt, why does this statute fail a rational basis test?
I think because James versus Strange laid out the specific principle about collection of court-appointed attorney fees without using debtors' exemptions. And that's what's happening with expungement. The state is saying you can't get expungement regardless of your economic situation now, because, I mean, frankly, in this case, we've got the expungement happened, or the request for expungement happened 9 years after the case was dismissed. So we don't know what's happened between the reasonable ability to pay finding, which may have been made in, let's say that the reasonable ability to pay finding had been made in the case back in 2009. We don't know what's happened to my client's financial situation in the intervening 9 years, and
Well,
whether she has the
should there be
reasonable ability to pay.
a second determination of reasonable ability to pay at the expungement?
So I think that would create a lot of administrative burden on district courts. You know, so right now, courts reviewing expungements just look to see whether under the expungement law, the case qualifies for expungement. They go through the criteria 901C2 and they figure it out. A reasonable ability to pay hearing would set up another, the need for another hearing, and I'm not sure that the court wants to take on that burden.
Well, but maybe we could say the statute by saying, if there's a constitutional problem, you say the statute by saying, well, reasonable ability to pay has to be current. I mean, I think you make a valid point. There might have been a determination 10 years ago, and who knows, there could have been, you know, unfortunate economic circumstances that render the defendant seeking expungement unable to pay. But if we construe the statute to require a contemporaneous hearing, does that drain your argument?
I still think that the expungement law, you know, using the expungement law as a collection tool, using it in a way to say, you can't get this remedy regardless of all these debtors exemptions. You can't get this remedy because we've determined your reasonable ability to pay and it's $200. And so come up with $200 and, you know, then maybe in another 10 years you can expunge this case when you come up on that $200. That's the problem I have with the statute as written.
I'd like to draw your attention to an argument by the state in their brief regarding the equal protection. The state is arguing that the classification of your client in particular, that it doesn't qualify, that the equal protection challenge does not survive because it's based on indigency. In other words, anyone who hasn't paid their fees, whether they're, I mean, the only people who qualify for having the expungement in this situation is if they haven't paid their fees. So that's the class, someone who hasn't paid their fees. Could you address that regarding the classification as brought up by the state?
So, you know, the state brings that argument up in saying that my client is not similarly situated to other individuals, and this court has expressed some reservations about that similarly situated threshold test. So it's sort of unclear what purpose that test serves, but to say that those who have repaid their debts and those who are not strikes me as a tautology that seeks to avoid the equal protection question, because we have, you know, the entirety of the class of people I'm arguing for is people who still owe court-appointed attorney fees to the state. Those are the only people who are not, sorry.
Are we really talking about defendants who have not paid their fees, who have the ability to pay and not the ability to pay? I mean, wouldn't those be the two separate individuals we need to look at? Because if you have the ability to pay, you shouldn't, I mean, tell me why you should not, your record should not be expunged if you fail to pay something you can play.
If the person has the ability to pay, then the state can use execution and garnishment to make sure that they do pay.
But we have all kinds of laws on the books here. You don't pay your taxes or child support, you lose your license. You don't, you know, you may use your your license to practice law. You don't pay any fines, you may use your driver's license. I mean, the code is replete of all that stuff. I mean, that's not unconstitutional to do those things.
I agree, Mr. Justice.
Let me throw out another example. Let's say, take the deferred judgment situation. Say that somebody makes a plea agreement, there's a deferred judgment is the deal, and as part of the deferred judgment, the defendant is supposed to pay their court debt. I suppose that's the deal, and then they don't pay that court debt, and so they don't get the deferred judgment is revoked, and then they don't get expungement. Is that unconstitutional?
Well, fortunately, we'll be able to revisit that case in a couple of months as I'm currently in the briefing stage on a deferred judgment case.
So I assume you feel that one's unconstitutional also.
I expect to make that argument.
You know, you make some good policy arguments that expungement would help people get jobs, find places to live. But I mean, even the Strange court acknowledged that the court's role is not to judge the policy wisdom of the position. That's for the legislature. Aren't we in the same position here?
I agree, except for the rule laid out in James versus Strange that says that it's invidious discrimination to treat indigent people who owe court-appointed attorney fees differently by circumventing debtors' exemptions. And
I happen to agree exactly with that. I think I agree exactly with that phraseology. Indigent defendants. I mean, Griffin versus Illinois, indigent defendants. And if your client is truly indigent, I would likely have a very real problem in the expungement context. But if your client is not indigent, the balance changes, surely, doesn't it?
I'm sorry, I see I've run out of time, so I want to be respectful.
You may respond to the question somehow.
So if the client is truly indigent, so you're saying, we're going back to what he said, which was, let's take another look at the reasonable ability to pay before, again, I'll say, I think that circumvents the debtor's exemptions in the same way that in James versus Strange. Thank you.
Mr. Poggenklass, thank you as well. Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court. Counsel, good morning. It's a privilege to be here. I want to start by isolating the nature of the equal protection challenge being brought here. And we try to do this in our brief. It's not a classification drawn on the basis of indigency. An indigent defendant, just like any other defendant, may obtain expungement after the fees and costs are paid.
Wait a minute, though. If I seek expungement and I'm truly indigent, I mean, I have nothing. Maybe I had money before, but now I have nothing. I cannot possibly pay. Are you saying I can't get expungement?
I would say that is what the statute says, and that's
and that's the problem with the statute, maybe.
Well, I think that's a legislative policy decision, right? I distinguish this from.
Wait a minute. I'm sorry to talk over you, but to condition expungement on an ability to pay when you're flat broke strikes me as a very serious problem. I mean, it's like saying you can hit someone for contempt for failure to pay a court fine, even though you don't have any money. Of course, we've ruled you can't do that. If someone seeks to statutorily established expungement to make a turn on whether or not you got, 2 coins to put in your pocket, strikes me as really problematic.
So I got 2 thoughts on that. The first is that it's made contingent on payment of costs and fees that at a previous point they had a right to a determination of their reasonable ability to pay when those costs and fees were imposed. So that determination is available to them, and they're only asked to pay costs and fees that they at one point had been found reasonably able to pay. And then the second point is that this is not like contempt imposed for non-payment. This is not an extraordinary remedy of the type discussed in James versus Strange. And this court recognized in 2011, there is no constitutional right to expungement. Expungement is not a fundamental right. This is a remedy that is being offered as an incentive for payment of costs and fees and fines. That's why it's made one of the preconditions of obtaining expungement. I don't think there's any obligation to offer it at all. And I don't think that conditioning the availability of that—
Didn't in 2011.
Right, exactly.
And I think we said it was constitutional to not offer it to people that were in Doe's situation, but to offer it to people who had deferred judgments and met the conditions of their deferred judgment. And so—
Of course, we have all kinds of.
Could I finish, please? And so, you know, given does the greater incorporate the lesser? In other words, can you offer expungement to people, to some subclass of the people that we didn't offer it to in 2011?
I think so. I think that the way the legislature gets to craft the availability of the expungement, this benefit that is that can be sought after the, you know, to set the conditions of when it's available, that they get to say you can't get expungement if you were found not guilty by reason of insanity. You can't get expungement if charges in the same case number were not dismissed, or if you were not acquitted of charges in the same case number. This is just another condition attached to something the legislature is not obligated to provide to anyone. And I think that there's good policy reasons to provide it, but there are also good policy reasons to require them to meet this repayment condition before offering it. There's, in 2017, the Legislative Services Agency found $167.6 million of outstanding indigent defense fees, or appointed attorney fees, excuse me, owed to the judicial branch. James versus Strange recognized that the state has a very legitimate interest in recouping outstanding court debt.
And how many of those cases was there a reasonable ability to pay really found as required by the code?
I'm not sure. What I do know is that the presumption of regularity in court proceedings, together with the idea that it's the appellant's burden to create a record affirmatively disclosing the error relied upon, right? And this court said this, I think it was a week and a half ago in Mom versus Jenny Edmondson Hospital, that in order for us to say something like there wasn't a reasonable ability to pay determination made at the time when the costs were imposed, there needs to be a record showing that that's true. I think Justice Waterman put it correctly here in the question where he said the record doesn't affirmatively disclose that such a hearing happened. It doesn't affirmatively disclose that it didn't. And I think that the record from what we do know in the record is that there was an agreement reached for dismissal, and then an unreported, a dismissal entered with costs and fees entered pursuant to some sort of agreement for dismissal that was reached. There's an execution of garnishment in the record that was then returned from the appellant's place of employment, saying she no longer holds this job. So at some point she had employment, and then the order was entered, and then she subsequently lost employment.
How do you distinguish Strange?
I'd say it's protection of debtors. So debtor protections and ability to discharge in bankruptcy, and freedom from contempt orders for non-payment. All of these fall into a category of the state can't use the stick to get at this non-repayment of court debt of attorney's fees. Can't use a stick that it couldn't use for civil, repayment of civil judgments and other debtors.
Expungement is not a stick.
I'd say that the offer of expungement is a carrot, and the state can make that incentive available and try to incentivize repayment. And if especially considering the fact that there was a preliminary, or at least there's the opportunity for a preliminary assessment of reasonable ability to pay, that solves the problem of the availability of this carrot to everybody. It's presumably going to be available to everybody to be able to achieve, to get there. But even in the situations where circumstances change, I don't think the legislature is required to disregard that legitimate policy goal, that legitimate interest in getting repayment of that debt that's owed to the court system. I don't think the legislature is required to disregard that.
Let me give you this hypothetical. Say this judgment is more than 10 years old and hasn't been renewed, or 20, whatever the statute is. It could be 10, it could be 20, depending on the nature of it. So it's no longer enforceable by the state. Does that mean that once that time goes by and the state doesn't renew that judgment, that you should get expungement because it's not due anymore?
I guess I'm not certain. I feel like in some contexts it's, well, I don't know. I suppose that in that situation, the applicant wouldn't have met the affirmative burden or wouldn't have satisfied the affirmative requirement of repayment.
Don't you have a James versus Strange problem because you're making their judgments longer than the judgments of other people, and you're not giving them the same benefit?
I think that would be, so the problem I have with that argument is that those two types of debt aren't even really similarly situated. That debt owed to the court system for the provision of an appointed attorney or court costs is different in the context of expungement than debt owed elsewhere.
But 910.8 says it's a civil judgment. It turns it into a civil judgment. So once the time runs out to enforce the judgment, and I don't know how, this is getting close, I don't know how close it is, how can you not allow expungement and run into the constitutional problems of James?
I think that your argument would establish a problem under Strange if the state were proactively going after the payment of debt using collection methods to try to force repayment, as opposed to offering something that the applicant can pursue and obtain if they meet the conditions set out in the statute. That there's no obligation to provide expungement at all. The state gets to set the conditions that need, or the legislature gets to set the conditions that need to be met before granting expungement aligns with the legislature's policy goals. And if those conditions aren't met, that's separate from the idea of going after somebody with extraordinary tools to compel or seize payment of that outstanding debt.
Seems extraordinary to me to say you can't get expunged until you pay a judgment that's not enforceable.
Well, and I think that bringing up the idea that the judgment becomes unenforceable after a certain amount of time, I think emphasizes the state's interest in making this a condition of expungement. That I think you're correct that at a certain point, you know, whether it's because of the operation of law or just because of pragmatic, you know, real world concerns, the stick stops working. That there is no way to, if somebody decides that they're not going to pay and they evade execution of, you know, there just may not be a way to force them to pay. The only thing that the state has left to do in order to recoup that pretty sizable category of expenditures all aggregated together is to incentivize repayment, to offer something in return. And that's something that the legislature is offering here is expungement. It's not something they're obligated to make available. It's just something that you can obtain if you make those repayments that you were previously found reasonably able to make.
It's another way to distinguish James v. Strange that court did not address a reasonable ability to pay determination.
I think that's true, yeah, that's accurate. That there was no safeguard of any reasonable ability to pay determination involved there, and that those extraordinary remedies were being applied without consideration for whether the defendant/debtor was able to make those payments at all. And I think that it's important, you know, I recognize that the similarly situated prong of the equal protection analysis has come under some criticism. I think it's important for two reasons. One is to clarify the nature of and the dimensions of the equal protection challenge. Because as phrased in one way, you could say this looks like a challenge of differential treatment between indigent and non-indigent defendants. But when you know, the similarly situated analysis kind of shakes it out. It's kind of like a sieve, and you're letting the sand fall through until you find the real distinction that's being alleged, that some indigent defendants don't owe any attorney fees, some indigent defendants are able to pay, some non-indigent defendants don't pay, and it isolates the real distinction that's being alleged as the basis for the equal protection claim, which is defendants who owe money to the state for appointed attorney fees and defendants who don't, or who owe private counsel in the event that that's possible. And then the second thing that the similarly situated analysis does that I think is useful is it makes it clear, or it's shorthand when it becomes obvious that there is a rational basis for the difference. Like in Wright, where the challenge is offenders on probation are being different from offenders who aren't on probation, that the full analysis would be there's a rational basis to treat them differently. The shorthand is they're just not similarly situated with respect to the.
Well, should the classification be based on the people that want to get their records expunged, but you have one class of people that have the ability to pay their attorney fees, and then you have another class that do not have an ability to pay their attorney fees? Would that be violate due process if that was the classification?
I don't think so. I want to clarify, and I think that you're referring to a present ability, not formerly, but possible change in circumstances. And I think that's a more interesting question. It's not really the question that's being raised here, in as far as I can tell, that there's no, and Doe throughout the proceedings has said she's not seeking to wipe away the debt at all, just saying that it shouldn't be a precondition to expungement.
Well, how much debt did you say that there's out there that is owing to the state?
Total, the Legislative Services Agency said $167.6 million.
All right, and what does the state make of that? What does that mean?
Well, I think it means that, and I agree that there is a need for better attention to the proper procedure that needs to be followed to impose it. I think that generally our district courts do a pretty good job, but they may not be doing it in every situation.
Well,
but I think that
are we putting people into a class of those that have an ability to pay that they really don't belong there?
I think
Because
by and
we
large,
aren't really digging into this question in a deep way if we've got all this debt piling up.
I think that there's not really any evidence to conclude that that debt is outstanding solely because people who, would pay and want to pay but can't. I think that there may be some of that, but another component has to be that the state's prior methods or the methods that are being used to collect that debt are just not effective at doing so, or not completely effective at doing so. And I think that's the purpose of some of the amendments that were cited in the Notice of Additional Authorities that are trying to, put some of this on local county attorneys' offices. I'm sorry, I see I'm out of time. If I can, thank you.
No, you may conclude and sum up.
Thank you. I think that's part of the legislature is getting inventive to find ways to make sure that the debt that's out there that can be repaid is repaid. And part of that is assigning it to local county attorneys who are presumably more familiar with who owes them money, who owes money to the court system and why, and how they can get it. And another part of that is making this benefit, not constitutionally required, available as an incentive to spur repayment where it can be made. And I don't think there's any equal protection problem with the state, conditioning the availability of this benefit on repayment to incentivize that payment. It doesn't distinguish on the basis of any protected class, doesn't burden a fundamental right, and there's very clearly a rational basis for the condition as applied here. Thank you.
Thank you as well, Mr. Sloven. Mr. Poggenklass.
Thank you. I just want to briefly revisit something Justice Waterman brought up. If this court were to remand for an assessment of Doe's reasonable ability to pay, I think there's another problem, which is the district court doesn't have jurisdiction to modify the amount of the debt. Under State v. Olson, that was the precise, the precise scenario was a defendant who was assessed court-appointed attorney fees, and then after Dudley came out, wanted to go back and revisit.
And that's a valid point, but couldn't we just make an up or down? I mean, the amount is $500 something roughly. Am I correct?
550, I believe.
Let me ask you another question. There is all this court debt outstanding, and some of I may have some of my facts wrong, but I understand that the judicial branch collects some of it and uses an outside contractor to do so. And when we do, that there is an additional 20% or something that's tacked on to the debt.
25, I believe.
25% that's tacked onto the debt. If somebody else is, let's say the county attorney is collecting it, that isn't there. Is it unconstitutional for us, should we be addressing that as the 7 members that are in charge, or 6 members, 7th to join us tomorrow, as a constitutional issue under the analysis that you're presenting?
So when a state contracted, I just want to make sure I understand the question. When a state contracted court debt collection firm assesses 25%.
In other words, you owe more if the judicial branch is collecting than if you owe if one of the other collection arms is collecting. Is that constitutional?
I see similar problems with that scenario, absolutely. But I just wanted to raise the Olson point, because if this court were simply to remand, I don't think the district court has jurisdiction to modify the debt. And so let's say that this court remanded to the district court, and the district court said, I believe Doe has.
We don't have to modify the debt. We could leave the debt there. We could just say there's no reasonability to pay, and thus there's no reason not to expunge. I mean, we don't have to get rid of the debt. We just say at the present time there's no reasonability to pay. And the code does allow for those things to happen under 910.7. The problem is you have to be sort of under the probation or incarcerated things. But
exactly.
The code does recognize things change. But we don't have to get rid of the debt to do that. We could just say if there's no reasonable ability to pay right now, you expunge the record.
Yeah. Things change. Clients like mine whose cases were dismissed never have the ability under 910.7 to go back and ask for
I understand, but what if your client won the lottery tomorrow night? What's it, tonight, $300 some million?
I believe in that scenario, and I didn't include it in the notice of additional authorities, but there is a statute that allows the state to offset lottery winnings before assessing the person's reasonable ability to pay. So I don't think we need to worry about that.
How do you respond to the state's argument that it's your problem if the record is silent on a reasonable ability to pay? It doesn't say there was that didn't happen. It's just not affirmatively shown that determination was made either way, and that the burden's on you as appellant, and that we presume regularity of court proceedings.
Well, I think this court suggested last year in State v. Coleman that the court has a responsibility to do the reasonable ability to pay determination. So I think we can safely infer from the fact that the court did not engage in that process that it didn't happen.
Didn't your client agree that she had a reasonable ability to pay by accepting the deal? Part of the deal was pay the court costs.
No.
And by saying, I will pay the court costs, isn't that some kind of acknowledgement that she has a reasonable ability to pay? She could have said, I can't pay those.
I don't think there's anything in the record that says that she agreed to pay the court costs.
Actually, I was looking at that and wanted to ask you a question along that same line. There is no mention of that. The agreement was that she would take the Family and Children of Iowa Family Violence Services class by a certain date. But I think the point that's important is, and nobody's backing out on that deal was sealed. She's asking for something else. She's asking for something, a benefit. So isn't that different? And that's the statutory requirement for anyone, that you can get it as long as your court costs are paid. So I don't think it's a violation of the agreement, but I wanted you to address the fact that this is some gravy she's asking for. It's on top of the dismissal.
Right. Gravy that would be completely available to people who had hired private counsel because they don't owe their debt to the public treasury. They owe it to a private creditor. Or
available to somebody who had court-appointed counsel and paid their fines.
Assuming they had the reasonable ability to pay, then she would be in a different situation if she'd had the ability to pay it. All right, thank you.
Mr. Poggenklass, thank you as well. Mr. Sloven, thank you again. Case of State versus Doe is now then submitted, and we'll next hear the arguments in Ruthers.